Respected audience, this is Naushab A. Khan, attorney at law, adjunct professor law. In this series of certain programs, we have been discussing different aspects of medical negligence. We have discussed that what constitute the breach of duty of care on the part of healthcare service provider. We have discussed that what is the dereliction of duty and what is the commission or inaction on the part of the healthcare service provider, which can result into a civil remedy or which can bring his act within the purview of criminal negligence. In furtherance of this discussion, we have shared certain provisions of relevant law which provides immunity to the healthcare service providers and healthcare establishments. And we have also discussed that how come this immunity or this umbrella can be taken away, and we have discussed the circumstances. And in case on account of any recommendations by healthcare commission, and if the doctor or the healthcare establishment is aggrieved of those recommendations, then right to appeal is available in law, and an appeal can be lodged. And we have discussed in the previous episodes that what are the remedies available and what are the areas which can accrue the right of an aggrieved person to lodge an appeal against the recommendations of healthcare commission before the learned district and session judge of the relevant district. Now, in the last part of this discussion, which relates to the healthcare commission, which relates to the provision of healthcare services at primary, secondary, or tertiary level, I'd like to conclude that here in Punjab, the law enforcement agencies are cognizant to this fact that any FIR which is usually lodged against healthcare service providers or healthcare establishment, the lodging of said FIR is illegal, unlawful, and illegitimate. And when I said that this is unlawful, I am of the view that since the relevant law provides that first of all, it is the Healthcare Commission which will ascertain that the allegations of medical negligence are correct or incorrect. And once Healthcare Commission has reached to this conclusion that the said negligence warrant any action by any other agency or the governmental agency, then it is the Healthcare Commission which can refer the matter to the concerned agency. The concerned agency cannot take the cognizance of the matter at its own. So it precisely means that when a complaint is lodged, an application is filed against a healthcare service provider or healthcare establishment to the concerned police station for lodging of an FIR, and the concerned police station, they, without adherence to the relevant law, they just lodge an FIR against healthcare service provider or healthcare establishment. That is absolutely nullity in the eye of law. And as I said, that the concerned police authorities, they are well versed with this law, but unfortunately, still this illegal act is committed against healthcare service providers and healthcare establishment. As I said, that this matter is very much in the knowledge of the concerned authorities, but of course, the element of its implementation is missing. Let me refer to one of the letter written by Inspector General of Police Punjab to his subordinates that against the doctors, the manner they opt to lodge FIRs is unlawful and illegitimate. I'd like to read few extracts of that letter. This letter is from the Inspector General of Police Punjab, and the subject of this letter is issuance of directions regarding the Healthcare Commission Act and the registration of cases against doctors. And it further says that the local police must ensure that in future all such applicants, aggrieved parties, be directed to present their complaints before Healthcare Commission for the redressal of their grievances. No direct action in connection with the registration of criminal case will be taken. That precisely means that the relevant provisions of Healthcare Commission Act provides that it is the Healthcare Commission, after due diligence and determination, the Healthcare Commission will pass recommendations, and these recommendations can be relevant to the civil negligence and the suit can be lodged, or if it is of gross criminal negligence, then of course law enforcement agencies can be directed that they can take the cognizance of the matter. So, since this area is a gray area and still FIRs are lodged, the Association of Family Physicians Pakistan, they are collecting the relevant data, and soon we are going to uh, launch a complete campaign uh, in order to build the confidence and in order to undertake the certain steps for the capacity building of the police department, to give them this awareness that any act on their part, as it is stated in the relevant letter by the IG police, that no direct action can be taken, and the concerned local police is directed by the chief of the province that if there is any application against the doctor, then the matter must be referred or forwarded to the Healthcare Commission. So, with these words, I must say that in order to safeguard your legitimate rights, first of all, make sure that you have employed doctors who are having valid license to practice, and on the other hand, your healthcare establishment is duly licensed by Healthcare Commission. And furthermore, if you are aggrieved of any of the order passed by the Healthcare Commission, and you intend to avail the right to appeal, then of course our law firm is providing the consultancy services. With these words, have a blessed day. Thank you.